Huge win the other day at the Rawson Law Firm. We won a felony stand your ground case. Florida's self-defense case law, also known as stand your ground, is where you are allowed to use violence against somebody else if you believe that violence is imminent, meaning that someone else is going to attack you. We had a case where our client Billy was on a cruise ship. We won't name what cruise line he was on, and he was at the bar in the cruise, and the victim of the case kept dropping his beers on the dance floor. If you've ever been on a cruise, what ends up happening when that happens is they turn the music off, they turn the lights on, everybody has to scatter out, and then they got to go and they got to clean up the mess. And the guy did this once, twice, 3 times, to the point where then every time the guy went back on the dance floor, they would preemptively stop it so that way he wouldn't spill his drink again. Our client decided to be the designated trooper to deal with this issue and confronted the victim about this. Luckily, there is footage of it. Our client kind of gets close to the victim and you can't hear what's being said. Victim touches our client first. Point blank. That's what the video shows. It's the victim touches our client first, and our client reacts with one single punch, a really good punch, right to the cheek, knocks the guy down, and that's it. Unfortunately, he is very efficient in his punch, and he knocks the guy's tooth out, which becomes permanent disability, which is what turns a misdemeanor battery into a felony battery because he now has a permanent injury that he lost his tooth. Our client is awoken after the boat docks by police.
Good morning.
Hello.
Hi. You need to speak to your husband?
Okay.
Who don't really tell him what's going on. They just say, hey, come out of your room. They don't say, hey, put your hands behind your back, and they arrest him.
Let's go. Let's talk outside now. Come on. Come outside. We're going to talk. Come on outside. We're going to talk. Put your hands behind your back. Put your hands behind your back.
Don't do that. Get your body cameras down, huh?
Calm down, sir. That's good.
And because they didn't tell him what was happening, he reacted as anyone else would if you're getting grabbed, and flinched. They ultimately charged him with resisting without violence. They actually roughed him up a lot. He got a concussion. I had to go to the hospital before he went to the jail. He's not from Florida. Billy hired us. We dealt with the case. He went and moved back to his state. While we dealt with it all, he had to come to Florida one time to deal with the case, which was for a stand your ground hearing. Before we even got to the stand your ground hearing, I had multiple different prosecutors on this case, probably 3 or 4. I begged them, hey, can we please dismiss this? We can pay some of the medical bills that he has. We're willing to do that if you just dismiss the case. That's fine. They kept saying, no. Ultimately, the week before the case went to the stand your ground hearing, I again got on the phone with the state attorney. I said, please call your supervisor. Have your supervisor watch the video. It's on video. Why are we disagreeing about something that's on video? Supervisor watches the video and says, there's no way Scott can win this motion. It's clear as day what's going to happen. I said, okay. We go, we have the hearing, and ultimately we win. The judge finds that the state did not meet their burden in the case to win. So we ended up winning. So the way it works in stand your ground in Florida is once we file a motion to dismiss based off stand your ground, we made it what's called a prima facie case. A prima facie means on its face. So long as the statement of facts of your motion spells out self-defense, you now then shift the burden back to the government to prove by clear and convincing evidence. It's an intermediate level, so it's not beyond a reasonable doubt, and it's not probable cause. It's in the middle. They have to prove by clear and convincing evidence that my client was not entitled to self-defense. Well, all they really had was they had the victim testify and they entered the video. We put our client on as well. I mean, it's very clear the client and the victim had very different beliefs of what happened. And the video, as you guys are going to be able to watch, not 100% clear what's being said, what's being done, but you do see that my client was touched first. And ultimately what the judge decided was that my client believed that he had to act in self-defense to stop the other guy from hitting him. And that's what matters in self-defense is as long as it's an objective belief that that person and that a similar person in that situation would believe that violence is imminent, then you are allowed, entitled to use self-defense. Florida also does not have a duty to retreat. So other states do have a duty to retreat, meaning that before you stand your ground, before you act in self-defense, you have to try to leave the situation. You have to try to run away. Florida does not have that in stand your ground law. So our client just had to be in a reasonable belief of imminent violence, and then he's allowed to defend himself. So it was a great result for a client who's never had a criminal history before, was on a family cruise with his wife and young kids, and worst cruise of his life ultimately. But luckily, he hired the Boston law firm. We were able to get that surveillance footage. We were able to attack the case the correct way and get the best result, which is a dismissal of all charges. So great question. So something that one of the ways I tried to get the state attorney to dismiss the case is in any case, you need to prove jurisdiction, meaning you need to prove that that Broward County, for Broward County, has jurisdiction over this case. Well, if it's on a cruise ship, how do they prove it? The argument I made to them was, you don't know exactly when the battery occurred. You don't know where the boat exactly was. Was it in international waters yet, or was it not? Well, there's a Florida statute that says that if a boat leaves from Broward County and the victim is from Broward County, that Broward County has jurisdiction. So for smaller crimes like batteries and whatnot, you're going to see those handled at the state level. But more serious crimes, so I have a friend that's a federal public defender who gets a lot of cruise ship cases. So those more serious crimes will be handled by the federal government.